So what are we going to talk about today? So we're going to cover a number of different topics. Yeah, careful. Patents, copyrights, the IP policy, some myths and some facts about IP, get things straightened out, hopefully in an interesting and entertaining manner. We're going to tell stories. We're going to laugh and cry a little bit. We're going to go home a little bit smarter from what we do. And I will hopefully try to answer all of your questions, hopefully if there's time, a robust Q&A. And if I can't answer your questions, I promise you I will make something up. And so Tony here is with the Office of General Counsel, patent attorney, and if I can't answer it, he certainly can. Okay, so let's get started. So I was thinking about, well, how do you start an IP talk and not make it boring? Well, I said, well, history. I love history. History is never boring to me. So I'm going to tell you a little bit of history about intellectual property. First, where does intellectual property even come from? How do we even come up with IP? Why is there IP laws? Well, the answer is it comes from the Constitution, Article 1, Section 8, Clause 8 of the Constitution. And it says, Congress shall have the power to promote the progress of science and useful arts by securing for limited time authors and inventors the exclusive right to their respective writings and their discoveries. So a lot of things in here. Number one, it talks about authors and inventors. It talks about writings and discoveries. And exclusivity is important, exclusive rights, and a limited time. So it doesn't say patents, it doesn't say copyrights, but it talks about inventors and discoveries, that's patents. And it talks about authors and writings, well, that's copyrights. And it talks about for a limited time, exclusive rights for a limited time. Exclusive rights means monopoly. So the intellectual property statutes in America are an exception to the monopoly, you know, the antitrust, thank you, the antitrust thing. That's why Tony's there in the front row. The antitrust thing. So it is a limited monopoly for a temporary period of time. So something to think about, the Constitution. So a couple of other interesting things about intellectual property. There we go. Sorry for those of you who are eating. If you don't want to look at the slimy, milky hands of this guy, don't take a look at that. Look elsewhere. But the question is, how do they get the vitamin D in the milk? So raise your hand if you know how they get the vitamin D in the milk. Not you, moron. Okay, anyone want to venture a guess? Just real quick. What's the obvious guess? Okay, great. Good feedback, everyone. Great. Okay, if you don't want to guess, I will tell you. Some people say, well, they must be an additive. Someone came up with the idea that maybe there's a vitamin D producing cow, and so the regular cows are over here, and the vitamin D cows are over there. Milk these, don't touch those, something of that nature. That is not the case. It came out of academic research. Harry Steenbach, University of Wisconsin, 19-teens, 1920s. He was doing rickets to cure, he was doing research to cure rickets in children. It was a serious problem back then, health concern back then, mostly with children, and they knew it had something to do with the vitamin D deficiency. So he had come up with a process by irradiating certain foods. You create a chemical reaction that creates vitamin D in the foods. And so he did it with rat food and then translated that to certain other foods. The most common one was milk because kids drank a lot of milk. So that was a really cool thing that came out of academia. It was applied to many types of foods. Milk it stuck with milk. And Wisconsin decided to commercialize that. So Wisconsin didn't have an IP policy. They didn't have a tech transfer office. And I'm having trouble. So they created one. They created the Wisconsin Alumni Research Foundation, the first tech transfer office in the Midwest. And they gave this idea to this group, and they went out and they protected it, and they got donations from alumni, built this up, got money to file patents, they protected, and then they licensed it to some companies to create vitamin D milk. And they ended up making more than $100 million over the course of the next 20 years. That's well over $1 billion in today's dollars. So it was a massive hit. And so that was one of the first major examples of a successful innovation coming out of academia. There were many others. That was one of the first ones. So moving along, some more history. Another historical activity is the Bayh-Dole Act of 1980, Birchby and Bob Dole. So they were trying to fix a problem that they saw, which was a growing trade deficit with the United States. More products being brought in and purchased than being sent out. And the problem that they identified was that researchers were coming up with great ideas, publishing on those ideas, and then companies would read about them, build them into their products, and then sell them back to the United States, causing a trade deficit. And so they passed the what's called Act in 1980, and before 1980, here we go, all inventions were owned by the United States government. if the government paid for the research. So most of the research was paid for by the government. The government owned all inventions coming from that research, and they could do nothing with them. They didn't have a tech transfer function, they didn't have a patent budget, anything of that nature, so they would just sit there on the shelf and nothing happened. So all the good publications, all the good technology kind of went to waste. So in 1980, they said, okay, we're going to change that. We're going to make it so that if you create an invention using federal funds, the university gets to own that invention. But they have to commercialize the invention. They have to protect it, they have to try to license it for value, and turn those ideas into products. And it made a heck of a difference. Before 1980, there was a handful of tech transfer activities here. After 1980, it became a requirement of universities. You had to have a tech transfer function under law. And you can see they popped up substantially after 1980, early 1990s. I think Vanderbilt's tech transfer function started in 1991, if I remember correctly. So moving forward, the American Invents Act of 2011 under the Obama administration. So, and this is a little bit detailed, but it's actually kind of important. The death of the first to invent, that's why the Grim Reaper's here. Under US law, if you, well, what was it? This is, yes, okay. So under US law, there was a weird thing in the United States that basically said, if I file a patent application on an idea, and someone else had filed that application first, and mine would get rejected based on their application being there first. But that I could show proof and say, oh, no, I actually invented this idea before they filed. And then they would reject theirs and give me the patent. But then they'd have a chance to say, well, wait a minute, I actually can show proof that I invented it before they invented it, before I filed, before they filed. And it just keeps going on and on and on. You keep going back and forth with this ping pong showing of proof. And it created this process called interference proceedings, where they just kept arguing back and forth on who invented something first. The rest of the world didn't have that. The rest of the world has a first to invent system, first to file system. We have a first to invent system. So in the rest of the world, if you file a patent application and you're the first one to file, you get the patent, even if someone came up with the idea first. So we regularize that in the United States. And so the consequences are, we're on the same system as the rest of the United States. Things became cheaper because there wasn't this big back and forth fight. But the consequences are kind of important. There's more pressure now to file earlier, which is not a great thing. Because in academia, you have unproven early stage technologies. It's, the more data you have, the stronger your patent is going to be. The more proof of concept, the stronger your patent is going to be. And if you have to file earlier, you don't have that. So your rights are a little bit more at risk, but you have to get to the patent office first. It does create a race to the patent office. But it's not that big of a deal, because when I got in this business back in the 1990s, having a US patent on something was probably good enough to commercialize it. In 2026, that's not at all the case. You really need to have international rights. So we're already operating under this first to file system anyway for the rest of the world. So it doesn't change things too much, but it did change a little bit. The other thing it changed, the American Invents Act changed, was it used to be like a death knell to your patent was to get inventorship wrong and to figure out who invented what and try to remember and go through your lab notes and things of that nature. That's not really the case anymore. Now, if you have it incorrect, then there are mechanisms to correct inventorship, whereas a long time ago, that was the easiest way to knock out somebody's patent, by claiming they had inventorship incorrect. So it fixed that problem as well. By the way, I said the rise of the first to file. It's kind of like the rise of Skywalker, if you guys didn't get the connection. Besides, it's a totally cool picture. This picture is the very first patent that was ever issued. It's X00001, 1790, signed by George Washington. So I don't know what it says. I can't read his writing, but I'm sure it's very important. It's probably a flying car or something. I really can't tell. So we're going to talk a little bit about patent laws. And so what is intellectual property? What are patents? Okay, well, intellectual property is just something that you create in your mind, not something physical, something, it's pretty obvious, right? It's intellectual property, something that you create, something that's intangible. But it is subject to protection under the law, and that's actually quite important. So we have to go through, this is the US statute on patents, and this is really important, so we have to look at this very carefully. So we'll just spend a few minutes. I'm just going to read this all to you very carefully. So whoever invents or discovers, yes, I am kidding, you're correct. So I'll read you a small piece of it to blow it up a little bit. Whoever invents or discovers a new and useful process, machine, manufacture, composition matter, or an improvement to any of those, you can patent any of those things. It's a very limited list of things that you can patent, but it's actually quite broad. Most things fall under any of these. There was a famous quote by somebody, a Supreme Court justice, that says, anything under the sun made by the hands of man or woman can be patented. So here's some examples, methods of doing this, new formulations, new drugs, new chemical entities, new materials, new designs, things of that nature. Many things can be patented. They fall under the category of a process, an article of manufacture, a machine, or composition of matter, or an improvement to any of those. So, how did the patent system come about? Well, our system came from Europe. We adopted a lot of the European mechanisms for this. Over the years, Europe has changed and they've adopted a lot of our systems in more recent times. But a patent is basically a contract with the government. It's a quid pro quo. And the deal is this. I will tell you, the government, I will publish everything that I know about an idea in painful detail, describing everything about the idea, so that others can read it and build upon it. That's a good thing. And in exchange for doing that, you give me a limited monopoly, a 20-year monopoly on that idea. So people can't use the idea, but they can read about it, understand it, and build in further science. So it's really a social contract with the US government. And that period of time is 20 years. In different countries, these things act a little differently. The time periods are different and whatnot, but that's how it is in the United States. So to get a patent, what are the 5 or 6 things you need to get a patent? Number one, in order to get issued a patent on an idea, that idea has to be useful. Okay, that's a pretty low bar. Not too worried about showing some use for an idea. It has to be novel. What novel means, it's kind of obvious. It simply means that that idea didn't exist. You couldn't look it up and find it somewhere. It wasn't in a journal article or something of that nature. You came up with it first. Now, what's a little less clear is obviousness. Your patent, your invention has to be non-obvious. And that is non-obvious in a legal sense, not what you and I think about being obvious. It's something a little different. Non-obvious means that if I take the body of work that's out there, all the different references, all the journal articles I can find on a subject and other patents, and I combine that with the normal learnings that people of that skill set, PhD in chemical biology or something like that, that they know. If you combine all the learnings and teachings of all the art, you cannot combine everything together and make your invention. And that's a hard one to get because there's a lot of pieces, parts of things all over the place. And so a US patent examiner is going to find this, going to find a little bit of that, going to combine a bunch of things and say, well, if you combine them all, then this is an obvious invention, so you can't get a patent. So that's a hard one it's a hard bar. Another barrier is enablement. In order to get a patent on something, you have to enable your idea. That means you have to describe your idea in such clear, concise, and exact terms so that someone of a similar skill set is able to read your patent and make or execute a process, whatever's in your patent. Make and do the same. And so that has to be, and without undue experimentation. It's reasonably evident how they would go about doing it. So that's kind of a high bar as well. And then the last one is best mode. Not only must you say how to make your product, but if there are variations on it, you have to tell the patent office and the world what is the best way of making it, what's the most efficient or most effective way. And those are all the criteria you need. Some are easy, some are a little bit harder to meet. But hopefully that kind of frames things, because if you're asking yourself as a researcher, when do I disclose an idea to like our office? When do we start this process? You can do it, it's hard to do it too early. Because if you do it too early, I mean, there's a difference between disclosing your idea, having a discussion with us, and actually filing a patent application. We can talk about things all the time early and have a plan for it. We may not want to file a patent application until you have some support data or proof of concept, or you've worked on the enablement element. So too early is not that much of a problem, but you do, for your patent, need to get data and you need to enable your idea. Too late is something you really can't overcome. If you disclosed it publicly before you've come to us and disclosed it to us, you may lose rights. It may be too late. If others have thought on it first, that first to file system, you may be too late. So who's an inventor? We get this question all the time. So, and this is, I think, really relevant to laboratory research. If in your laboratory, you have a lot of people working on projects, or a particular project, you have lots of pairs of hands. So what constitutes an inventor? And the answer is, don't worry about it. It doesn't really matter. We'll figure that out. We'll hire an attorney. The attorney will figure out who's an inventor. Tell us who contributed to the idea. But nevertheless, to answer the question, there are two elements of an invention. You have to conceive the idea in your mind, okay, in clear and concise terms. Conceive of the idea, think of it, think about how it is, how it works, and then you have to make the thing that you just thought of. So the first one is conception. The second one, the making, is called reduction to practice. And in the patent world, conceiving the idea is a contribution of inventorship. Reduction to practice is actually not. So there's a big difference. So an inventor, or those who have conceived of the idea, not necessarily who has reduced that idea to practice. However, in the course of building something, you may make modifications, improvements as you're doing that. And so even if you didn't conceive the original idea, you could have added things to the idea during the reduction to practice process, and therefore have contributed to the conception as well. So you can contribute to conception as part of the reduction to practice process. So it becomes really complicated, and that's why you want to talk to a patent attorney about who's an inventor, who contributed what elements to it. Suggesting an idea, boy, we really need this. Boy, we really need a flying car. Suggesting an idea is not an invention in and of itself. Patent versus publication. Now, maybe the most important thing you can take away today, and I'm hoping that most of you already know this. I hope this is not new ground. If you publicly disclose an idea before you started the patenting process with us, then several things happen. You start a clock ticking in the United States, 12-month clock, which means you got to now reduce the practice, enable it, get data, support data to proof of concept things within that 1-year period. Otherwise, you're not going to have enough data and information to file a patent application. So you put yourself under the gun by starting this talk. Outside the United States, they have an absolute novelty system, which means as soon as you publicly disclose something, if you haven't had a patent started by the time that you disclosed it publicly, then you have given up all your non-US rights. And that can be a very big blow to commercialization. Very difficult to commercialize something if you've given up all your non-US rights. A couple things about this. Just talking generally about an idea isn't necessarily a public disclosure. Even in something as detailed as a journal article, you're not necessarily disclosing the idea, because you have to disclose a lot of detail about the idea for it to be a public disclosure. It has to be enabling. Which means if you described your idea publicly in a way that someone else of your skill set could take it and make it, then you have disclosed it publicly. But if it's just generic statements and a lot of the details are not there, it's not really a public disclosure. I would not risk it, okay? But nevertheless, that's something to think about. Secondly, your disclosure must be in writing. So in the United States, that is, not actually outside the US, but in the United States, the statute says the public disclosure must be in writing. So if you're talking to someone about it, kind of casually, well, maybe that doesn't count. If you give a presentation like this with slides and there's written materials behind you, it does count. Okay, there's already case law on that, so I wouldn't risk that either. But there is a little bit of wiggle room for the level of detail and the way that you've disclosed it publicly. Publications are clearly public disclosures. Okay, what else we got here? The two can coexist, certainly. We can file, we've had this, I don't know how many times, where someone is at a conference and just realizes at the last minute, oh crap, this is going to be a public disclosure, this presentation I'm giving, and they call us up and say, what can you do? We can get something on file. It won't be good. It's not ideal, but we can get something on file to protect your rights same day. So whatever it is you've disclosed publicly, we can protect that at least on a provisional basis, on a temporary, preliminary basis. So we can do that. Usually we'd like to have a few weeks, but we can do it in a day if we have to. So the patenting activities do not have to get in the way of your publication activities. Do not even have to get in the way of your presentation activities. So there is one thing that you do have to know. If you're going to engage in the innovation ecosystem and you're going to patent ideas and commercialize ideas, the US patent system is a lousy tell-on-yourself system. So you can't bury articles or things that you know about or things that you find because you're afraid that they may adversely affect your ability to get a patent. If you come up, if you know something, or if you come up with, if you find a reference that if the patent examiner in Washington, D.C. knew about this reference, it would harm my ability to get a patent. You can't hide that. You have to tell about that. So it's a duty of candor with the US Patent Office. Now you can discharge your responsibility by telling someone like me that, and then we can pass it on in the system. But everyone involved with the patent system, you, us, our attorneys, whoever, has an obligation to let the Patent Office know of any other art that's out there that could affect your patentability. Patents and software. So patents protect ideas. Software protects the expression of those ideas, the original works of authorship. And there is quite a bit of difference between them. So software code, this is really about software. Software code is typically protected by copyright. So you write down code, that's your expression. You can copyright the code that you write. Can you patent the code that you write? Well, a method of doing something, remember that list of 5 I said, methods and articles of manufacture and machines and what was the other one? Chemicals, yeah. Those things can be patented. Methods can be patented, and we often encode methods, encode algorithms into our software. So you're not really patenting the software, you're patenting the algorithms that you're encoding in the software. As you're using the software to carry out a method, and that can be patented. So people talk about software patents, and that's probably fine. It drives me up a bloody wall. But there aren't really a software patent, so to speak, but you can patent algorithms in software. And so you can do both. So AI, if you have your AI system write some software for you, what can you do with that? Well, as it turns out, the Copyright Office has reaffirmed multiple times now, you can only copyright human-created expressions. AI-created expressions are not available for copyright. That's not a great thing, but it is the law. So, however, let me see here. If you prompt an AI system, your prompt or your series of prompts is insufficient to be considered a contributor to the resulting AI software. And you are not an author, and that software is still not protectable by copyright. Now, there are some exceptions. The exceptions are complicated. There's this hybrid idea. The hybrid idea is basically if you are iterating with the AI and your contributions are substantial. Sorry. Fumble. I don't know if it still works, but I guess we'll find out. Yes, it still works. If your contributions are substantial, then your contributions and that AI software may be copyrightable. But the problem is this. Under the law, only the human contributed portions are protectable and the non-human portions are not protectable. I don't know what to do with that. It's all kind of mixed together. I don't know how you even pull those things apart. So it'd be very difficult to understand what type of protection you could actually get if you and AI together created something. Okay, we're going to hit the policy, the Vanderbilt IP policy quickly. This is very interesting stuff. Who owns inventions? Answer, Vanderbilt. Okay, if you work at Vanderbilt University and you make an invention, we own that invention. If you work at the medical center and you make an invention, well, Vanderbilt University still owns that invention. And so we work with everybody. There are exceptions to that. If you're consulting and your work is not overlapping with your university research, you're just consulting and using your expertise, and you clear it with your department chair or your dean or whoever is appropriate ahead of time, then you get to own those things. I've been here, what is it, I don't know, 15 years now. No one has ever cleared anything with the department chair or their dean ahead of time. It just doesn't happen. You guys aren't wired that way. It's like a year later, oh, I have this invention. Oh, did you talk to your dean? Well, no. Okay, whatever. So we kind of ignore that last piece, okay? We don't try to hang you for it. But you can own your own things. So we own it when it's within the scope of your employment and or using any institution's funds or facilities. That's when the university owns it. Otherwise, you get to own things. This is the same everywhere. It's not like a Vanderbilt thing. It's all universities do it this way. All companies do it this way. It applies to both VU and VUMC. And so, but imagine what it'd be like if that wasn't the case. Okay? This guy's imagining. That's the picture. Imagine if this were not true. Imagine if you owned the inventions that you made using federal funds or industry funds. If you took an industry research contract, and you own, so the contract is with Vanderbilt, but then you own the results. The company, that contract's going to say things like they get access to all the data, they get access to research results, they get perhaps a non-exclusive license for research purposes to inventions or things like that. If you owned it, they couldn't access that. How would you contract it when you own these rights and they couldn't access those rights? So industry research contracting wouldn't work if it didn't work this way. Even foundations, people think, oh, foundation money is fantastic. Most foundations have a clause that basically says if you commercialize the results, you have to give them a piece of the action. Any money that comes in, they get a portion of it. Sometimes it's a specific amount, 10%, whatever, 15, whatever it is. Sometimes it's you get a portion, they get a piece in proportion to their relative contributions to the project. I don't know what that means, but it means something. And if they give you money, they can't access that revenue sharing element if you own the invention. So it really has to work this way to get industry funding, to get foundation funding, and certainly federal funding as well. The good news is, if we make money, you get half that money. And hopefully, a lot of people know this. Vanderbilt's one of the most generous institutions in the country in terms of sharing commercialization revenues with their innovators. with their contributors. I call them contributors, not inventors, because again, you don't have to figure out who's an inventor and who's not. Tell us who's contributing, who gets a share of the money, we'll take care of that. So here's the percentage that you get of the breakdown, half the breakdown. In academia, it's usually around a third. I've seen 20%, I've seen 25%, I've seen up to 50%, and we're at the 50% mark ourselves. So contributors are identified in disclosure forms. Don't worry about who the inventors are. You don't have to be a legal scholar to figure that out. And contributors, your share, if you contributed to something and you get X% and you leave, that share goes with you. You will always get that percent as long as money comes in. I've been trying to get that changed for the longest time because I think, screw you if you leave. But we'd be a severe outlier if that's the case because everyone else does it this way too. So couldn't get that passed. So it definitely follows you, and it will always follow you wherever you go. Okay, so who administers interprets the IP policy? And what if there's a dispute? What are some disputes that could occur? Well, one dispute would be, I invented this thing in my shower, and I didn't use any university resources. I think it's mine and not yours, Vanderbilt. Okay, we may disagree. And our office gets to decide who's responsible. We administer. We get to make the first call on that. But you can appeal that to the Technology Review Committee. The current chair is Eric Scarr. So you can appeal that. Another example of dispute would be, I was put down as a 10% contributor to this invention. I think I contributed 20%. I think that 10% is wrong. I should get more. Then you have a dispute between researchers. That happens more often than we'd like. Those are some examples of disputes. The Technology Review Committee is a faculty-led committee that hears and adjudicates these types of disputes. And it's led by Eric Scarr. I actually have a picture of them in action here. So there's a dispute going on, there's Eric fixing things. So TRC, so call him. But don't tell him that I have a picture of him. I'd hate to have him find out, So I'll send the slide if I have to. So institutionalizing things, so institutional perspectives. The main institutional perspective that I want to share is patents are expensive, okay? We don't just get patents for fun. Patents are not a vanity thing. They're not meant to be like something, it's not an accomplishment in and of itself. It protects an idea. It's a means to an end. It is something that, it's an economic vehicle that allows you to commercialize an idea, to create new products so that the public has new products, new therapies, safer cars, cheaper cell phones, things of that nature, so it benefits society. So the real purpose of getting a patent is to enable somebody to pass on that monopoly. The patent's a monopoly. I get the monopoly, I pass on to a company with their promise to spend money to turn that into a product. And then they sell the product and that helps people. It makes our society better. New products are good. And everyone makes a little bit of money off of it. Yes, that's a means to an end. But we don't just get patents because I want to get 50 patents this year because I got 48 last year. That is not a good use of institutional resources. The purpose of a patent is to enable commercialization to create new products. A company will not invest in a new product if they don't have a monopoly on it through the patent, because then their competitor can just look at what they did and reproduce it for much cheaper. So patents can provide a competitive advantage. When would they not provide a competitive advantage? There's actually a lot of reasons they may not. They can be very narrow. If you can only get a very narrow patent, then people can invent around that patent rather easily. Find another way, a variation on a theme, get around your patent and make it basically useless. Your rights may not be enforceable. There are certain method patents that even if I can get a patent, I can't enforce a patent because I don't know what companies are doing behind the scenes. And I don't know if they're using my patented method or some variation of it that wouldn't be covered by my patent. Some things you just can't tell. Sometimes I can get a patent, but it's dominated by someone else's patent, and I can't actually use it because someone else has dominant rights. There could be a lot of competition. There could be regulatory challenges. There's a lot of reasons not to get a patent as well. So things to keep in mind. Patents can be difficult to secure if you don't have enough proof of concept. Okay? The breadth of what you can claim in your patent is directly dependent on all the research that you've done, how much data you had to support it, and what variations that you have actually enabled. If your technology isn't optimized, they won't give you broad protection. However, I will say this, there's time to speculate. So academia, in our world, in an ideal world, I would only file a patent on something that I knew would be commercialized, that'll be licensed to a company. Because companies take that on and they pay the patent costs, or they reimburse us of the patent costs. So I spend no money if I file a patent and then I license that patent and get the money back from the company that I license it to. That's the ideal situation. That doesn't happen in academia very often because our technology, what makes it sexy is it's early stage and unproven, and it's new, and it's novel. It's no one else has this. It's the new stuff, and so they want to license the new stuff, hopefully. But a lot of companies are like, that's a great idea, but I'd be crazy to invest in that idea in its current state. Come back to me in 2 years after you've developed it and proven it quite a bit more. So it can be hard if you know something is really good. If you've done your analysis and it says there's a market for it, it is protectable. I've spoken to a few companies and they said it's very attractive, but too early stage to actually make an investment in. Then I sometimes have to speculate on that. Sometimes I have to just file a patent and hope that things work out. I like to look to make sure that the researchers have more money to continue to develop it, or we have internal mechanisms to find translational resources at Vanderbilt to invest in that further. And we can talk to you about that. But we do have to speculate. So we have to hope sometimes that the things we think are going to be valuable will end up being valuable down the road a few years. So not an ideal business case. And this is what the business case kind of looks like. And this is pretty close to being accurate. Around 20 to 25% of disclosed ideas to us are commercialized, are licensed to a company. Of those that are licensed, only less than half of them actually make money at some point in the future. And I don't mean right away, I mean at some point in the future. And of the ones that make money, a fraction of them only make a real good amount of money, like over $1 million. So you're really getting down to 1, 2, 3% of those that can make a fair amount of money. It's a difficult game, right? It's early stage unproven technology. Once it leaves your hands and it's licensed, you can't control what the company does and how much money they put into the development. There's just a lot of variables in it. Competition comes along and your idea becomes not as interesting as it was 2 years ago. There's a lot of things that factor into the success. Okay, so yeah, we're getting close to the end. I'm going to go through some interesting patent quotes. I have no idea if they're interesting. I thought they were interesting because it's hard to find a good patent quote, frankly. I'll be honest with you. So Albert Einstein, only sure way of making mistakes is to have, only sure way to avoid making mistakes is to not have any new ideas. And then of course, Mark Twain, the two most important days of your life are the day you were born and the day you found out why. Now I looked at that and I was like, okay, I think he means like at some point you do something great and you're like, okay, that's why I was put here. But when I first read that, I was like, I just envisioned like my mother coming to me and says, hi, I wanted you to meet Brad. Brad is your real father, or something like that. It just was like, it was a weird quote, and I was misinterpreting it, but then I understood it eventually. So I was pretty happy about actually figuring it out. So going back to the Chief Justice of the Supreme Court, anything under the sun made by the hands of man is patentable. Everything that can be invented has been invented. So the Commissioner of Patents said, everything that's been invented has already been invented in like 1899. All right? That's like the Secretary of Education being told to close the Department of Education, I think, something of that nature. As it turns out, this is a famous quote, but as it turns out, he didn't actually say that. He actually said the opposite. So they got it wrong in the history books, but he's basically, this is attributed to him. Patents are for the weak, and they're landmines for warfare, says Elon Musk on some crazy night high, which could be pretty much any night, actually, as it turns out. And I think, Tony, you were saying something about how many patents his companies have.
He said, ironically, SpaceX holds hundreds of patents.
Yeah. So yeah, what do you do with that, right? So okay, so moving on, something a little more upbeat. The patent system is the fuel of interest to the fire of genius, right? So there's this fire of genius. How do I harness that? Well, I can get a patent for something and commercialize it, and it's good for the public. Good old Abe. Abe is also the only U.S. president that has a patent as well. If you didn't hear my prior talk on can patents block my research. A nation without patents is like a crab that can only move sideways or backwards. Okay, it has the word patent in it. I mean, I'm not even sure what he's even saying there. I think you're not moving forward, I guess, is the point. But I don't know, Mark Twain's a little nuts. But Dyson is not. Dyson, I have a lot of Dyson products in my house, and so I really appreciate his perspective. Without patents, R&D would not be worth the investment. So think about that. That's that one is really relevant to us. Okay, so facts versus myths. Myth and fact. So patents slow down publications. I think we covered that. We can file something same day if we have to. Patents and publications can coexist, no problem. Patents are to blame for high drug costs. You hear that a lot. Most drugs are not covered by academic patents, so it doesn't really relate to us. Secondly, those that came out of academia, the average royalty is like 3%. So if you feel like your drugs are 3% too expensive, that's probably our fault. But if it's the other 197% that you're worried about, that's a whole bunch of other factors that has nothing to do with the US patent system. So, you know, God love Bernie Sanders. He has this wrong. He simply just has it wrong with his trying to come up with new ways of re-importing, getting around patent rights and things like that by re-importing drugs from Canada and all that stuff. So researchers shouldn't publish, shouldn't patent. You should just focus on your publications. And that may be okay. And how do you get notoriety in academia? Well, you publish things, right, in high impact journals. Well, let me just tell you, there's another route to impact. And that second route is coming up with the nascent ideas that lead to new products and new services that benefit society. So you can have tangible impact by helping create new products. And not only would I say that you can do that, I would argue you have a moral imperative to do that. Because the alternative is someone like me is going to have to figure it out. And I don't know anything. I barely can tie my shoes. That's why I have slip-ins. So this is really up to you guys to change the world. It's not, if not you, then who? Nobody makes money patenting research. We have tangible evidence to the contrary. We've had several dozen millionaires that we've created in the past 25 years at Vanderbilt based on income from their inventions. That's that 50% thing that comes in. Patents, this is a weird one. I just threw this one in there because people are, like in a journal article, you're so worried about, like for a chemical that's a therapy, you're so worried about the mechanism of action. How does this work or how does that work? In the patent world, who cares how it works? All you need to know is it does work. It's a totally different system. Very bizarre for some people, but it's just different. Okay, quick facts. I will go through the quick facts quickly. Patents are expensive. They cost around 25 grand to secure in the United States over a very long time, 5 to 7 years from first filing. So it's not a quick system at all. They take 1 to 2 months to draft. And by the way, if you need that non-US protection, you can leave if you need, Stephen. It's okay. Okay, yeah, I'll go one foot out the door anyway. It's like, okay, when can I slip out? I'll look this way, and then you can leave. Go ahead, go ahead. Oh, you didn't leave yet. Okay, so if you want protection outside the United States, it's another couple $100,000. So imagine 250 grand for one patent, and we get 250 inventions a year. If we patented everything everywhere, we would have no money very quickly. So we have to make very hard decisions. So some speculation is important to do. You can't speculate on everything because you don't have the money for it. We don't have the money for it. A provisional patent application can be done the same day. We covered that. Patents last for 20 years. And disclosing an idea before you disclosing an idea before you begin the patent process, you can lose rights. Okay, so copyrights. Copyrights are a little different. They're very cheap to secure a registration for copyrights. Unlike a patent, which takes 7 years on average to issue, as soon as you write something down on the computer or on the page, a copyright attaches to that. It happens immediately upon your creation of it. Now, even though you have a copyright upon creation, it is always better to file a registration application for copyright. They take about 6 months and they cost about, I don't know, 200 bucks or something, 120 bucks or something like that. So they're very cheap. We'd cover that, of course. But they're very cheap to get. And the reason why you want a registration is because you cannot enforce a copyright against anybody unless you first registered it. You guys have seen, I'm sure in the past, when you used to use DVDs, you get the thing at the beginning that says, under penalty of law, you can't reproduce or copy this movie, otherwise you'll face civil and criminal penalties and $200,000 in fines or something like that. Well, that is statutory damages for infringing copyrights. You have to file your registrations in order to get that. Okay, key takeaways. We're in the last leg here. Researchers, this isn't me telling you what to do. This is just, hey, letting you know. If you're researchers and you're working on a federally funded inventions, you have an obligation under law, under the Bayh-Dole Act, to disclose that invention. You have a legal obligation to disclose. That's an important thing to know. And then you have a legal obligation to tell us everything about it under Rule 56, the whole tell on yourself thing. So it's a really lousy system. If you have an industry research contract, the contract with the sponsor says you have to disclose inventions. And if you have a foundation contract, the contract with that foundation says you have to disclose inventions. So you should always think about disclosing when you're doing research. Institutional policies apply both to BU and VMC, but so do all of our services. Everything that we do, we do for everybody. Inventorship is tied to conception. This is a little more detailed than I had before. If you suggest an idea, you have not conceived of the idea. It's an invitation to invent. Otherwise, I invented the idea of putting a pedestrian bridge across West End Avenue, okay? Because I did that a long time ago. But it was just an idea. I'd actually make it. I don't know how to make it. So if you are just a pair of hands using ordinary skill to make something that someone else invented, you are not an inventor. But if you are creative in the process of doing so, you can be an inventor. And if you only contribute to, okay, they're similar, but if you contribute just to the reduction of practice, not the conception, then you're not an inventor. At Vanderbilt, contributors share in the revenues, not just inventors. I should point out that is not the case. Unlike the situation where the university owns your inventions everywhere you go, that's pretty similar everywhere. In this particular case, there are a lot of universities where you have to be named the legal inventor to share in the revenues, and other contributors get cut out. Vanderbilt is not like that. It's pretty close to 50-50, in all honesty. So that's a subtlety. When you're looking for jobs elsewhere, that's a subtlety. Public disclosure before starting a patent is unfortunate. Patenting and publishing can coexist. A lot of things, this is just a summary here. Patents are a means to an end. They're not the goal in and of itself is to get patents. We want to commercialize them for public benefit. And I just threw in another president, Thomas Jefferson. Thomas Jefferson volunteered to be the first commissioner of patents because he hated the idea that a patent is a property right under law. And so he said, well, I want to be involved with this process because I don't want any perverse incentives to occur that will harm U.S. commerce. So he decided he was going to take over the activity because he hated patents, he hated this whole idea. He ended up becoming a big fan, but at first he was very much a skeptic of the whole system. And lastly, there's a lot of things that are on the market because of work in academia. There are more than 200 drugs on the market that came out of academic labs, FDA-approved drugs in the United States. There are hundreds of thousands of medical devices on the market, and many other types of things as well. My wife loves the fact that Duolingo came out of an academic institution. This is the first time that we connected in like 30 years. I was like, oh, I do Duolingo. You work with technology like Duolingo? It's like you. It's like if you weren't out of my league, I'd have dumped you long ago. Anyway, so thank you for putting up with this talk. Very much appreciate it. Just want to mention that our next Lunch and Learn is going to be sometime this fall, and it's going to be on venture capital, how we can work with venture capital in positive ways. I think that'll be a good one. And if you want to keep up with us, this is for Andrea, right? There's our information.